My name's Susan Shaw and I'm an environmental lawyer and the founder of Living Law. We are a globally focused public interest law firm based in Scotland and amongst a growing movement of lawyers who strive to use our expertise to protect people and planet. We work across national, EU and global laws to bring a multi-level governance perspective to tackling key environmental challenges facing the planet today, and we advocate the importance of rights-based dimensions to environmental law, both human rights and nature rights, as essential prerequisites to realising environmental justice. I'm also extremely privileged to have recently joined the expert members network of the United Nations Harmony with Nature initiative, which you will have the chance to find out more about as we go through the course, as well as being a member of the IUCN's World Commission on Environmental Law, which is another exciting platform which brings together lawyers who are working towards these common visions and goals to uphold all our rights. I'm delighted to be able to join you today on your journey through this inspiring new course, which is being hosted by Maria Valerie Beros and Nicholas Ferrucci in the university, and it's very much at the forefront of disseminating knowledge of these latest legal developments. And as you will have been finding out, it's an extremely exciting time for you to be participating in this learning experience, as these cases are starting to flourish right across the world, as there is growing recognition of the importance of the imperatives to move beyond our failed anthropocentric perspectives and towards earth-centred law and jurisprudence. At this moment, we are facing great challenges to realise the future we want, and we need committed lawyers like yourselves who are ready to bring their expertise to address some of the greatest challenges of our time. I've been invited today to share with you some of my own experiences of environmental litigation and some strategies we consider when preparing our interventions and legal actions. I hope that this will provide a useful foundational perspective for then further consideration of the specific cases in the nature rights field and why we need to urgently shift beyond traditional environmental law. We've also shared with you some further written materials via the online platform for you to read in your own time, and we look forward to engaging with you virtually with any follow-up questions that you may have. At this point, I would particularly encourage you, if you haven't already, to read a recent report which was prepared titled Giving Nature a Voice, Granting Nature Legal Rights, and is authored by one of Living Law's talented former interns, Erica Solomeo. This report provides an important contribution to comparative legal analysis of recent nature rights cases in Ecuador, Bolivia, Colombia, New Zealand and India, to name some of the key jurisdictions that we've examined. Since the report was written, however, a number of other cases or authorities have also emerged, and so I'd encourage you to review also the work of the Earth Law Centre in the United States, which has an excellent newsletter and other resources on this subject matter. So let's move on to talk environmental law and litigation. In my career to date, I have worked initially on traditional environmental laws across government, including drafting environmental laws and in applying them within local authorities, the environmental regulator, private practice and the third sector, including establishing a pan-European litigation project for a prominent NGO. Living Law works across all of these spheres in line with our mission statement and increasingly with local communities who are concerned to protect nature. I can only share with you my own experience and perspective from my work to date, but in my opinion and without exaggeration, traditional environmental law is often too simply legalising the destruction of our planet through an almost box-checking approach that starts often from a legal presumption that harmful activities will be consented. People and planet frequently do not feature in the decision-making process, and nature is viewed merely as property to be endlessly and unsustainably exploited by a minority to the expense of the majority. At the same time, traditional environmental laws have also often become increasingly sophisticated and highly specialised, creating a regulatory gauntlet for local communities to navigate in order to protect nature. For example, in setting environmental permitting standards for industrial activities and processes, which are often heavily influenced, indeed even written, by industry lobbying and may be watered down further as part of the eventual legislative process adopting them. Against that background, it perhaps should come as little surprise that when these laws are applied in the real world, that the impact is that they are failing to stem the rapid decline in nature. Another dimension to this is the enforcement deficit in environmental law, which is of course already well documented. For example, the UK prior to Brexit had a highly sophisticated system of environmental law, but yet is also amongst the most nature depleted countries in the world. Nature has been quite tolerant and forgiving, but as we know is now starting to send us the invoices for our unsustainable actions as we approach and in some cases transgress non-negotiable limits or tipping points in the Earth system. As a generalisation, governments across the world are behind the required change curve in understanding and applying the best scientific advice, and so are failing to take the necessarily decisive action to align human activities with planetary boundaries and the safe operating space. To understand the scale of the challenge, one only needs to read the report from the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, the IPBES report, which was launched last year and highlights that 1 million species are now threatened with extinction. Stemming this decline mandates system-level change, and this has of course also been brought into sharp focus by the recent COVID-19 virus, and now is an opportune moment where there is the possibility to build back better and recognise our interdependence with nature, and as such the importance of aligning our laws with higher law and with what science is telling us. Moreover, the decisions that have allowed this position to manifest also reflect profound inequities in existing governance structures and bring them into sharp focus. Given that one of the first principles of any legal system is equality before the law, it should also then be little surprise that people who do care about our one home increasingly turn to litigation and to our courts to right these inherent wrongs and seek that they uphold our environmental rights and nature rights. Whether litigation is ever the optimal solution to address and resolve these complex and multifaceted challenges is, however, much debatable and something that I would encourage you to debate. But as things stand, cases of this kind are only likely to set to grow, for example as climate attribution science and the evidence of environmental destruction begins to fill evidentiary gaps in establishing the causal link. We need talented lawyers, civil servants and judges and others like yourselves to be ready to deal with what is coming, as these cases will increasingly land at the feet of our courts. I think this subject is also something that the legal profession does need to urgently grapple with, and whether it's ready to deal with what's coming. These are amongst the reasons that we have started through our work to explore also the concept of nature rights as one tool to help stem environmental problem shifting, and perhaps most importantly, to address due ethical prerequisites which our current approaches are failing to align with. These considerations are particularly acute in the litigation field, and although our specific legal systems are often very different, particularly between common and civil law jurisdictions, my own experience is that there are profound similarities in the challenges that we are facing collectively to address these issues. For that reason, taking a cross-jurisdictional perspective is extremely beneficial. And for sure, no one is suggesting that the law alone can address environmental challenges facing the planet today, but I'd suggest it's perhaps far more naive to think we can address these challenges without the environmental rule of law. Environmental rights and nature rights are essential prerequisites to delivering any notions of justice, fairness and equity. They are also essential, therefore, to address often hidden power dynamics and increasing attempts at power grabs. And again, these are further reasons we believe of the need to recognise nature's inherent rights. Yet environmental rights, let alone nature rights, are still frequently dismissed, often by those who respectfully simply do not understand its concept or are opposed to the concepts for the precise reasons we argue that recognising nature's rights is important. For sure, no one is suggesting that nature rights can replace the need for detailed regulatory controls. What it does offer is an exciting opportunity and an optic through which to reimagine environmental law and help to deliver the normative shift from our failed and failing anthropocentric perspectives by reconnecting with the often forgotten fact that we are nature. In this regard, there is much to be relearnt also from Indigenous perspectives. As I'll come on to explain, we now argue that just like children or adults who lack capacity, there is in fact an ethical prerequisite to be made that nature needs its own voice to move us beyond our failed anthropocentric perspectives. And there are very clear, practical and deliverable mechanisms that can be considered to start to achieve this shift, such as through legal governance structures and in court procedures. We'd like you to think about what they might look like and encourage your innovation and creativity. Turning back specifically to litigation, it's important in introducing the topic of environmental litigation to highlight that clearly every case is not the same. Environmental litigation today can cover a vast range of issues, so I've tried here to classify tentatively some of the main categories or types of litigation that you will encounter in this field. Again, there's not a single way to approach this, but I mentioned some of the main ones. So strategic litigation has become an increasingly fashionable topic. Such cases can be developed to help test new or novel areas of law, and then if they're successful, help establish a pathway for others with less resources to apply that law in future or indeed in other jurisdictions. Some of these cases, such as the Urgenda decision in the Netherlands, have been nothing short of revolutionary. However, this is also a field where I would caution there's a careful need and imperative to balance due ethical prerequisites with the drive for outcomes. In addition, it's important to consider whether you risk losing or weakening an argument or lever that you might otherwise have in administrative procedures if you're unsuccessful. Then reactive litigation, such as what's happening with the Trump rollbacks in the United States. This also now applies in the UK in the Brexit context and in several other countries currently working in a climate where regressions are being attempted. More broadly, these cases highlight the importance of recognition of the concept of non-regression both globally and nationally across the world. Constitutional cases, such as the youth bringing cases against the Norwegian government's proposed drilling in the Arctic in the Norwegian Constitutional Court, and closer to home in Scotland, Scottish ministers are also bound to comply with human rights under the Devolution Settlement, the Scotland Act 1998, and following the greening of human rights in recent years, this therefore provides a backstop or benchmark in respect of certain environmental rights. You may find something similar within the laws of your own jurisdiction. And more traditional environmental law, for example, intervening in relation to permitting matters, such as on industrial emissions, or seeking to uphold environmental impact assessment laws, you can research the work of groups such as CELDEF in the United States, who also explain well what the shortcomings of these traditional laws are in practice. Industry-driven, defending injunctions, interdicts against protesters, such as in relation to the removal of mature trees or at development sites. Defending SLAP litigation, that is strategic litigation against public participation, which is an increasing challenge for many environmental actors, in particular where you are seen to pose a serious and credible threat to vested interests. And I'd refer you in this regard to recent cases about Resolute Forests and Greenpeace, which has actually had a good outcome, but equally underscore that dealing with these often spurious claims can be highly resource intensive for NGOs and others, and are often specifically intended to divert attention and focus from your real work. And then the more novel nature rights cases, such as the Atrato River in Colombia, where the court recognised nature's rights ex proprio motu. This has admittedly not been without any limitation in terms of the enforcement of the judgment, as you can read from the materials that we have shared with you. So as an environmental lawyer, what kind of things do you consider or need to consider when you're bringing a case? Firstly, obviously, what is the objective you're seeking to realise? Are you simply trying to enforce the environmental rule of law in a particular location? Are you trying to establish a precedent that can then be applied to other matters? The case you bring might not be on the highest profile issue for this very reason. Perhaps you're seeking to open the space for wider policy debate and create a catalyst for the development of new laws. Clean air litigation has obviously been important in this field. Or do you in fact want to show that the law does not do what the executive branch might be claiming that it does? And then you need to consider, is litigation really the best or optimal means of achieving your client's objectives or nature's interests? I've mentioned there what's called negative precedent, showing that the law doesn't do something. This can be highly controversial, and some lawyers would see this as universally a bad thing. But it's also something I'd encourage you to debate with co-participants on the course. Is it better to have a law that pretends to do something only on paper, or is it better potentially to show its inherent limitations? The fact may act as a catalyst for future legislative change. And of course, some of the answers to these questions will clearly not be universal and may depend heavily on the jurisdiction you're working in at the particular time you're bringing or considering the case. Secondly, what is the forum you're planning on bringing your complaint for? It may be the national court, or it may be that you're ultimately seeking to bring the matter before a supranational court or body, for example, the European Court of Human Rights or the Inter-American Court of Human Rights. It may be that you're also lodging a complaint with an international treaty body, such as the UNECE Aarhus Convention Compliance Committee, or, as is often the case with high-profile matters, it may in fact be some combination of different fora simultaneously and in tandem. Thirdly, what is the precise strategy? For example, how will campaigns be aligned with the legal work, whether by your client or an NGO, or also trying to mobilise wider public support and a coalition? What is the evidence base you need to rely on? For example, what technical expertise will you need to lead? Often you may find that industry has developed its own experts, and different experts may argue very different positions. What legal concepts can help in that scenario? For example, if the science is unclear, are you arguing for the precautionary principle or approach to be applied? And then remedies. What is it precisely that you're asking the court or other body to do? And again, this will vary between jurisdictions. As a public interest lawyer, your objective is usually not going to be compensation. In the UK, the courts have been quite reticent to engage with what is viewed as substantive review of administrative decisions. They will defer heavily to the position adopted by government, nature conservation and regulatory agencies, for example on issues like species protection. Traditional judicial review procedure in the UK may simply send the decision back to the original decision maker to correct some procedural flaw. So winning a case may not in itself guarantee a specific outcome or change. And then there has been a move, to challenging this and mandatory orders being sought. And again, for example, here in relation to clean air cases. Where EU law is engaged, we're often asking the national court to refer a question on the interpretation of EU law to the European Court of Justice in Luxembourg, what's called the preliminary reference procedure. And this can then be extremely useful in Europe, as the ruling can then be applied across all of the countries thereafter. Examples of this have included things like how to interpret the meaning of disturbance of species protected under the Habitats Directive, which is an offence. And then, what are the risks and how are you going to manage them? For example, you might risk losing the law as a lever in administrative decisions in future. And whether you're considering more traditional environmental litigation or some of the more novel cases that we're talking about, increasingly you may find yourself potentially also having to consider them in tandem with other laws which may have very little to do with the environment or the specific case you're bringing. For example, protection for whistleblowers might be increasingly important, upholding the rights of and protections for environmental defenders, or other areas of law, such as advertising law to challenge corporate greenwash. Of course, one of the critical issues is usually who's going to be bringing the case. Do they have standing before the court? And who can speak for nature in your jurisdiction? In the UNECE region, you have the benefit of the Aarhus Convention, so you might be working with an environmental NGO. Latin America has now similarly agreed the Escazú Agreement and moving forward with it. In the UK, there's a famous quote from Lord Hope in 2012 in the UK Supreme Court, which always sticks in mind, where he highlights that an individual may be personally affected in his private interests by the environmental issues to which an application for planning permission may give rise. Noise and disturbance to the visual amenity of his property are some obvious examples. But some environmental issues that can properly be raised by an individual are not of that character. Take, for example, the risk that a route used by an osprey as it moves to and from a favourite fishing loch will be impeded by proposed erection across it of a cluster of wind turbines. Does the fact that this proposal cannot reasonably be said to affect any individual's property interests, rights or interests, mean that it is not open to an individual to challenge the proposed development on this ground? That would seem to be contrary to the purpose of environmental law, which proceeds on the basis that the quality of the natural environment is of legitimate concern to everyone. The osprey has no means of taking that step on its own behalf any more than any other wild creature. If its interests are to be protected, someone has to be allowed to speak up on its behalf. But today, in 2020, we increasingly need to ask, is it enough that we can speak for the osprey? And should we even be looking at the osprey's situation in isolation? We can argue that nature's rights to exist, thrive and flourish in its dynamic life cycles in fact need to be recognised and given its own voice or perspectives to assure environmental justice. And it's this question that we are seeing courts around the world begin to grapple with. How can nature be afforded its own voice? What nature rights should be given recognitions? When we begin to consider these issues, we can find very clear examples and inspirations also from other fields of law, which illustrate well that the fact that a claimant is unable to speak for itself is not at all novel in any legal system. Take, for example, the evolution in the recognition of the rights of the child before our courts in the UK, the unborn child, or the representation of people with mental incapacities. Here in the UK, this has often involved the appointment of a nominated representative of the court, called the curator ad litem, to represent those interests in the judicial proceedings. And what once was seen as ridiculous or unworkable is now entirely mainstream. And of course, we know the rights of corporations are clearly recognised before our courts already. So then, is it actually not absurd that nature's rights, on which all of us depend to exist, thrive, flourish and regenerate in its dynamic life cycles, are not represented unless someone, such as an NGO, specifically tries to represent those interests and is resourced to do so? And the need for this recognition can be seen further from an ethics perspective. Increasingly, we also need to ask and be concerned about who is attempting to speak for nature. Do they represent nature's interests or some other unseen interests? Again, these issues are not new to courts and can also be seen clearly in the field of the rights of the child, amongst others. As I've mentioned, the beneficiary of litigation may not be who you first think, but some things to consider are who is funding the litigation, who really benefits from the litigation. For example, in clean air cases, it may be investors in proposed green technologies or other solutions, but they may be simply looking at a single environmental issue in isolation for others, as opposed to the holistic perspective that the Sustainable Development Goals mandate. What other motivations are there? The 3 Fs, funding, fees and fame, invariably feature, and there are often hidden other motivations, such as political ones. For sure, environmental litigation can also be a source of profit for someone and can conceal power dynamics. Without nature recognitions, it's questionable whether there is a driver to actually resolving these issues and to delivering harmony with nature in our current legal systems. And as you'll see from the reading materials we have shared with you to analyse, the answers being developed to these challenges by courts and governments are varying, with one of the most successful examples to date in New Zealand, where guardianship type structures have been created to afford protections to nature in its own rights jointly by the government and Indigenous groups. But there's also a question who guards the guards that remains. I'd flag that this entire debate was brought into sharp focus in Scotland recently, where a fracking company, INEOS, tried to sue the government based on its human rights being deprived by moratorium by the government on fracking. That is in terms of Article 1, Protocol 1 of the European Convention on Human Rights. This case was highly flawed. Environmental groups knew from the outset it was unlikely to be successful, But had there been nature rights recognitions in our law, it's likely the case would not have been arguable, thereby avoiding the diversion of resources needed to address it and the uncertainty until judgment was pronounced. So we must question, is it not in fact more straightforward for courts who are used to balancing and taking into account many different interests to make some estimates about what nature needs as compared with, say, the fracking company? What is it that's making nature less worthy of rights-based protections before our court? Key challenges with litigation. So obviously, regardless of the precise area of litigation, many of the challenges will be the same. Costs is the most obvious one, even with the Arhus Convention in the UNECE region and now moving towards the Escazú Agreement for Latin America, the practical barriers to litigation can still be significant. And you often need to be prepared to stick with the case and be resourced to do so until you can eventually get the decision from a higher court that's being sought. And this is an area where we can also look to consider changes to court proceedings in future. Eco-imperialism remains a tricky balance, and the need to consider whether a case risks fueling the Brexit type scenario. It's important that as part of the campaign you are seriously considering simultaneously issues such as just transition and impacts on those who may be dependent currently on environmentally harmful practices for their survival, for example artisanal gold mining and the use of mercury. There's practical challenges, obviously we've talked briefly about evidentiary issues, and then also tactical ones. The other side can often try to just bury you in documents and disclosures, and litigation is unfortunately rarely either a quick solution. Again, it can take several years to resolve a case, which may then become somewhat theoretical to the issue you're dealing with, unless it's been possible to obtain interim orders, such as injunction as it's known in England or interdict as it's known here in Scotland. You may find that the government is in fact happy to litigate. Remedies: not getting the outcome you want. There are rarely few clear winners and losers in litigation. The remedies may sometimes also be weak or of limited enforceability. And then judicial culture is obviously changing, but there can still be some misguided perception that these cases stray into political territory. Courts, however, are right to guard against attempts to pass the buck for the difficult decision to the law, and I would suggest that addressing these issues in the long term lies directly again in assessing the issue of remedies and whether the remedies that we currently have available are adequate. Vested interests, again, the potential for the abuse of the litigation process. Attempts to improve access to justice can have unintended impacts, but these are issues that as a lawyer you need to be alive to and to your ethical codes of conduct. And then backlash and perhaps negative publicity. Some NGOs may be opposed to the idea of using litigation in view of the risks mentioned earlier, and sometimes object to more principled approaches rather than simply to looking at the outcome. So in summary, I've highlighted some key examples of the types of the risks involved in litigation, but it does also come with great opportunities. The key is, of course, to factor these considerations into your planning. But that said, no matter how much preparation you do, litigation is still always going to be akin to some degree to throwing a stone into the pond. You can't guarantee exactly where the ripples will end. So for these and many other reasons, we believe that governments should also recognise that we simply cannot make these transitions without the environmental rule of law, and that nature rights optics are now essential to help us to reimagine environmental law and one part of the tools available to guide humanity towards harmony with nature and stewardship of the Earth system. For those of you who may want to go into further depth and find out more about the issues we've touched on, we've given you 3 cases to read as examples of litigation that have begun to recognise nature rights, and we'd like you to analyse them and see what similarities and differences you see that exist between them and also in their practical application. What challenges do you think would have been encountered by those who brought these cases? And then we've given you one more traditional environmental law case and encourage you to consider how the outcomes or the process of this case might have been different if the law in your country recognised nature's right to exist, flourish, regenerate and evolve. Thank you very much.